WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. Thank you for tuning in. If you have been injured or even arrested, if you need the services of an attorney and, well, you haven't done that yet, you might want to consider it. John Fuller is here to answer whatever questions you might have about that. He, of course, is an attorney here in Ocala at the law firm of Fuller and Fuller. And this show is called Legally Yours. And sometimes John is in court. So let me tell you what date it is so that you know whether we're live or not. It is Wednesday, June 11th, 2014. If that's the same date on your calendar, then you're listening to a live show and you are invited to call in with your questions. The phone number is the WOCA Climate Control Source Hotline, 622-WOCA, 622-9622. Good morning, John. How are you?
Good morning, Larry. It's good to see you. We were absent last week, so it's good to be back live and hopefully get some live calls from our listeners. But it's always a pleasure to be here and to talk about the law. We do practice trial law, Social Security disability law, complex family law matters. And if any of our listeners or their families or friends have a question or an issue, we'll be glad to talk about it generally. If it's a case that you need legal representation in and you don't have a lawyer, then certainly we'd be happy if you called our law firm. We'd be happy to talk with you and see if we could help you in an individual capacity. But it's nice to talk in general terms about some of the issues that come up, and we have some interesting ones from time to time.
Yeah, sure do. It must be an embarrassing thing for somebody who's never been arrested to suddenly find themselves needing an attorney because they were arrested.
Oh, it's a horrific experience.
That's gotta be.
All my observation of people, and you know, there's many times people who come from, you know, very respectable backgrounds who have never ever run afoul of the criminal justice system, are caught up in it. And of course, we definitely want to say from the very beginning that everybody in this country enjoys a presumption of innocence. And so the mere fact that a person is arrested certainly does not imply that they are guilty. But it is a devastating prospect. In fact, people who are very responsible, respected, solid citizens who, for whatever reason, find themselves arrested, I think it is horrifically traumatic. I know it is from the clients that I have represented over the last 40 years or more. And you see some people who have, unfortunately, for whatever reason, frequently been involved with the criminal justice system. Mm-hmm. And this just another one of the events that they have experienced before. But you get first-class people who are professionals, business people, solid citizens, and they get stopped for DUI. That's a major criminal offense now.
Yeah,
it used
sure.
to, when I started practicing law, it was serious, but it was so much less. It impacted your life so much less then. It was the first offense was tantamount to almost a traffic citation type thing.
Yeah. Now
it has serious consequences, far-reaching ramifications, potential for jail time, loss of license, and anyone who is arrested for DUI has to spend 6 to 8 hours or more in the county jail before they can be released, even if they have a bail bondsman or a family member there with the cash to post their bond. They have to hold them under the concept that they've been arrested for DUI, therefore they're intoxicated, therefore the jail doesn't want the responsibility of releasing somebody before there is sufficient time for them to have, quote, sobered up. Either way, somebody's probably going to spend a portion of a night in jail, or certainly a considerable time, and it's a very unpleasant experience.
If you would like to call John, I encourage you to call now because quite often, and I'm not so sure what the psychology is behind this, but sometimes we get the calls at the very last minute. It's so hard to squeeze them in. This would be a great time. 622-9622 is the number. And I will stop talking if you call. Why did we change from driving while intoxicated to driving under the influence? What is the difference?
I don't know, other than maybe change for change's sake. When I started practicing law, it was driving while intoxicated. The statute changed because the legislature was trying to make it easier for the prosecutors to get a conviction, because if it said driving while intoxicated was at least arguably higher standard of proof than under the impairment.
Impairment is what I mean.
Yes.
Okay.
So now it's while driving while under the influence to the extent that your normal faculties are impaired.
Okay. And it looks like you've got a couple of phone calls coming in, so we'll take one at a time. Good morning. You're on the air with John.
Yes, good morning, Mr. Fuller.
Good morning, sir. How are you?
Very good. Glad to have you back. Enjoy your program very much.
Well, thank you. I'm sorry I had to be tied up last week and couldn't be here in person, but it's nice to be back and it's nice to hear from you.
Well, you know, the replays are, sometimes you'll miss something that are just as fun listening to as a live program.
Well, thank you. It's nice to know that I'm still entertaining even when I'm not here. I think probably Larry does a better job, when I don't interfere with him.
Well, Larry, no doubt Larry's great.
Larry's a star.
We just recently had one of our very fine circuit judges being appointed by the governor to appellate court in Daytona Beach. Is this like a promotion or an assignment, and is this like the highest spot you can go in the state?
Well, those are two or three good questions there. First of all, I do want to offer again my congratulations to Judge Brian D. Lambert, who is without question one of the finest circuit judges in the state of Florida, certainly one of the finest that I've ever practiced before. I am very, very pleased and proud of the fact that I hired Brian Lambert while he was in law school to work for the law firm I was with as a law clerk. Actually, my partner at the time, Bryce Ackerman, was the one who interviewed and hired him, and he worked with us, tried a lot of cases with me, was very gracious in his comments at the bar luncheon that I had been a positive influence in training him, and I was it was very touching for him to publicly acknowledge that. He will be an outstanding district court judge. As far as it being a promotion, it's a different type of judgeship. You don't try cases with a jury. You hear oral argument. It is more academically tuned because you are looking and researching the precedent and comparing it to the record to see whether or not the trial judge that presided over the trial committed some type of reversible legal error. Brian has an absolutely extraordinary intellect. He graduated from high school about 2 years early. He attended college in Eastern Michigan on a full tennis scholarship and was one of the top-ranked male tennis players in the Detroit area, and beat a number of budding young professionals, including Aaron Crickstein and Jimmy Arias, who in the late 70s went on to play Wimbledon and that sort of stuff. He was maybe 1/10 of 1% before being a professional tennis player. And Brian, if you don't know him, is about 6'3" or better, and at that time weighed about 220 pounds and was cat quick and had unbelievable hand-eye coordination. Still does. Great family man, been married to his lovely wife Kathy, who's a registered nurse at the Villages for 27 years. And they have 3 lovely children, all of whom are very successful in their own right. I don't know that you would necessarily call it a promotion. it's been a long-time dream of Brian's to be on the District Court of Appeals. I am so delighted for him. He will do a great job, but I temper my enthusiasm and happiness for him with the sadness that we, as lawyers who practice in the courtrooms of this jurisdiction and toil in the pits, if you will, and fight the battles, are losing one of the finest circuit judges that is practiced in the state of Florida. And I think if you talk to any judge or any trial lawyer who had any experience, they would say the exact same thing. So we wish him Godspeed and all the best. We shall miss him, but I know he and his family are very happy. He applied for that position, and this is a good life's lesson. He applied for that position 8 times before he got appointed.
Wow.
Every time he applied, there were 20, 30, 40, 50 lawyers apply, and he made the short list of 3 to 6 people to go to the governor.
Wow.
There is, of course, a political process. The governor gets the last say. Some of the previous governors, I will not name them, but one of the time before last that his name went up on the short list with overwhelming, impeccable credentials, he didn't get appointed. The person that got appointed was a partner in a very large, high-profile firm in another city. He appointed that guy. When that governor went out of office, he immediately got a job with the law firm where the guy he had appointed. So like I say, people can draw their own conclusions. However, there's obviously the reality of politics and everything we do in life. And I commend Governor Scott for appointing Judge Lambert because clearly on the merits, he is well deserved of that position.
All right, that was interesting to hear.
The difference in the money as far as salary, you can look it up on Google. I don't know what it is, but it's probably not $5,000 or $10,000 a year difference in terms of annual salary. Yeah.
And you have another phone call. Thank you for waiting. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller.
Good morning, sir.
Yeah, I think Judge Sawaya too was a guy that was appointed to, I guess, one of the appellate courts too.
Yes, Judge Sawaya is from Ocala, and he was the first and only judge from this area appointed to the 5th District Court of Appeals before Judge Lambert's recent appointment. Judge Sawaya has been on the district court bench, I don't remember how long, but a long number of years, and he is an outstanding jurist. He is another lawyer who I've known for many years in this community, and he has an outstanding intellect. And when you see appellate judges, they are more into the little intellectual aspects of analyzing law and writing legal opinions, scholarly legal opinions. Judge Sawaya is an excellent appellate judge.
Yeah, I know him and his friend. I got a question though, in regards to charges. A lot of times I notice when people are charged with certain crimes, it seems like sometimes even the deputies or the police officers or whatever, sometimes they have a tendency to pile on. Now, what happens when a person goes to court and they whittle those charges down and dismiss some of them? Does that become a permanent part of the record, or in terms of arrest, or how's that handled? I've always been kind of amazed about how they do that sometime, and I guess it's kind of to get people to plead or something. But I'll hang up and listen to you. And I always enjoy listening to you.
Thank you, sir, and thank you for your question. It's hard to answer that question because it depends upon the facts of each individual case. And so it's really hard to answer a general question with a general answer that would be specific enough to be meaningful. If you're charged with a crime and the crime is dismissed, you do not have a criminal record. You do still have on your record the record of the arrest, and you have to take a separate proceeding to have that arrest record sealed or expunged. Otherwise, even though you were acquitted or the charges were dismissed and you were not found guilty of the charge for which you were arrested, you don't have a criminal record of an adjudicated criminal case, but you do have a record that you were arrested and charged. And that can sometimes be very punitive when you go to get a job or what have you. And so there is a procedure, a statute, that allows people to go to court, and if they meet the requirements of the statute and the rule, to have the record sealed, and then ultimately, after a period of time, to have the record of the arrest expunged. So then it is as if it never happened. If you have plea bargained in the case, where they charged you with 3 offenses, but they dropped 2 and you pled guilty or no contest to 1, you may then have a criminal record if the judge adjudicates you of guilt. If the judge elects that he is not going to adjudicate you guilty, but withhold adjudication of guilt, even if you were charged and pled and had to do probation or pay a fine or house arrest or whatever, if adjudication of guilt was withheld, you don't have a criminal record. If you plead guilty to a crime, then that can be used against you in a civil case as an admission against interest. That's why they have the available plea that the judge has the discretion to accept. Latin again, nolo contendere, means that I do not contest the charge. But there is a factual basis, and there's a provision in the criminal rules, Florida Criminal Rules of Procedure, that says there is a methodology for someone charged, if they choose not to contest it, to enter a plea of no contest as a plea of convenience while maintaining their innocence. For a practical purpose, it has the same effect as if you pled guilty, because you're not contesting the charge, and the judge can sentence you to whatever he wants to. They just cannot be then used against you in a parallel civil case, for instance. Say you were arrested.
Oh, okay.
Say you were arrested for criminal assault and battery, and you pled no contest to that, and then say the person who claims that you hit them and hurt them sues you civilly for civil assault and battery. Well, if you pled guilty to the criminal, it's an admission in the civil case. If you pled no contest in the criminal, they can't bring it up in the civil case.
Okay.
So it really is a complex question with multiple components to it, and you can't draw a whole lot of conclusions if you don't know all the details.
The phone number right now, if you'd like to call John, is 622-9622. If you have a legal question, go ahead and call, and you are welcome to interrupt anything that we might be talking about.
It's true, and before we go too far afield, because I do want folks on this program to know, our law firm Daily helps people who have been hurt in automobile accidents or through the negligence of some third party, whether it's maintaining a negligent premises that led to a fall, or whether it's an automobile accident or some other type of injury. Those are very important concepts that you have valuable legal rights that have to be addressed within 14 days of the accident with medical care, and you need to seek out legal counsel. And if you've been in an accident, or you are injured, or a member of your family has, and you want to speak to someone, you certainly feel free to call us 352-547-4292, and we'll be happy to sit down. If we don't make a recovery for you in a injury case, a negligence case, you don't owe us anything. If we do make a recovery, we charge the standard percentage that's allowed by the Florida Supreme Court and the standard contingency fee contract. But it's very, very important, and it's very important to do that early on after the accident.
And it looks like you have a phone call, John.
Very good.
Good morning. Thank you for calling. You're on the air with John Fuller.
Good morning.
Good morning.
This has been a really interesting discussion. And I'm becoming fascinated with legal strategy. So I have a kind of a comment, or maybe it's comment and a question. If I'm charged with a crime, the prosecutor's going to want a conviction. If I'm stone cold guilty, it's probably better for me to maintain a low profile and not get too much media attention to my case. But if it seems like the people who either have a strong case for being innocent, or maybe there's some kind of quirk in the situation that is newsworthy or might come to their advantage, it seems like these people just run to the TV cameras or their representatives do and try to get as much attention to the case as possible. And I just was wondering, Mr. Fuller, and I'll listen on the air, but could you kind of go over that a little bit and how that's handled by a team of lawyers that's preparing for a trial? Thank you.
Well, it's an interesting question. It's a difficult question, and the answer depends upon the circumstances of each case. There isn't a formula. You can't go look it up or type it into a computer and they tell you what to do. It's brought about by your experience, your judgment, the nature of the case, what is happening. Unfortunately, to some extent, we live in a world where there's 24-hour news shows, or at least shows under the guise of being called news shows,
Right.
that are nothing more than talking pundits with an agenda who want their 15 minutes of fame about talking about somebody else's case. They're not always constrained by the facts and the evidence because they don't know it. And there's an awful lot of people who are out there who may be prospective jurors who would ultimately be called to sit on that case. And cases ought to be tried in the courtroom. You're absolutely right. In fact, there are rules that says that there should not be extrajudicial statements. But our friends in the media have a job. They have to sell newspapers. They have to sell radio airtime. They have to sell television shows and things that are scintillating and sensational or what do that. So they have a job to do. They don't have to abide by the rules of evidence. They don't have to abide by the rules of due process. They don't always pay a lot of attention to the presumption of innocence. And at some point, decisions are made that that you have to win the trial of public opinion. One of the things I admired greatly was Mark O'Mara in that Zimmerman case. I thought he handled it very professionally. He was appropriate in his comments that I saw in public, but he was not out there hawking his wares trying to sell his case on the nightly news. He went to court. In my opinion, he significantly outlawyered the prosecutor. The prosecutor, the last I heard, there was some sanctions pending because of discovery violations where they failed to disclose exculpatory evidence that they had. They ended up firing one of the employees in the prosecutor's office because that individual blew the whistle that they knew that there was evidence that was there that was exculpatory to the defendant, and they had not disclosed it in a timely manner. And people don't know that even though we have rules and even though the vast majority of the people that participate in the system are honorable, professional, ethical lawyers and prosecutors, that may not always be the situation. And I'm not picking out one particular case, and I don't know the details of that, but generally that was reported in the news that was going to be an issue after the trial. Whether it was or it wasn't, or whether there were defenses to it, and maybe there was absolutely nothing wrong, all of those are possibilities. I don't know, and I'm certainly not being critical of anybody. But it's a balancing act, and generally, I always took the position that I wasn't going to try my cases in the press. And I have seen my clients in high-profile cases get terribly abused, and there goes the Battery family, terribly abused by statements reported as news that was fundamentally flawed and just completely incorrect. And so that's a problem. And there goes Andy, They didn't hear that, but those are all friends of my son's. So anyway, it's nice to see friendly faces go by.
Yeah, yep. That's one of the cool things about being here. And real quickly, what is your number, John?
The office number is 352-547-4292. We have a toll-free number, 855-534-2565. We have offices in Ocala and the Villages. And if you have a specific case that involves you, your family, or a friend of yours, we'd be happy to talk with you. And if it's in an area we practice and we can help you, we would be pleased to try. Certainly appreciate all our callers today.
All right, excellent. Good job. And call us if you need John Fuller's number repeated. Thank you, John.
Thank you, Larry.
We'll see you next week. We'll take a little break. We'll be right back.
Broadcasting from the Paddock Mall Studios, this is WOCA, Ocala, Gainesville, The Villages, 1370 AM, 96.3 FM, The Source.
It's time for Farm and Ranch headlines on the Southeast AgNet. I'm Tyron Spearman reporting. Well, peanut farmers are in the short rows now. USDA says they are 95% planted in Georgia, about 81 with finishing up in